So my task today is to give us an update on where we are on fraudulent transfers in the state of Florida, and for the reasons that Dennis alluded to, fraudulent transfers are alive and well in the state, and I think we've been in a 10-year bull market of fraudulent transfer planning. And I don't mean that in the sense that they're effective. I meant that in the sense that they occur, and I seem to encounter various attempted conveyances and ideas for conveyance, and also because of attorneys, not me, but attorneys who refer clients to me have come up with various ideas and plans as the attorneys learn that they are freely now able to think and advise and discuss the issue. The next few minutes, or the time I'm speaking, this is, I always think there are attorneys who like tax and there are attorneys who do not get tax or like tax. This session will be for those who do not like tax. There's no math. And what I'm going to try to do is discuss more practical aspects of the issue as a practitioner. There's a discussion later today that deals with case updates on asset protection, including fraudulent transfers. So my materials have some cases, but I didn't really do an exhaustive search or shepherdization of the cases because I don't want, this is not intended to be a recitation of new cases, but again, more of a practical discussion. And what I'd like to do is for those who are sort of in asset protection or occasionally do it, just to try to teach you from my experiences what works, what doesn't work, how you should treat the issue, and most importantly, the mistakes that I see. So what I want to do is just take an overview and a practical view. The idea of a fraudulent transfer in practice, it doesn't, I see that it doesn't really come from attorneys. It certainly doesn't come from me. I mean, I don't sit down with someone and say, okay, we'll just transfer everything to someone else because I know it's not going to work. It comes from the debtors, and it starts with the phrase, what if? Okay, so what if I gave everything to my wife? What if we have a trust? What if we, who knows, combine things, they put my real estate in an LLC. So it usually starts with the what if, and it comes either when the client sits down, it often comes when they call me on the phone. The ideas, and even the ideas that seem relatively effective, usually start with the client. It's not something where you can research some kind of cookbook or a manual about how to do a fraudulent transfer. I mean, that's not where these ideas come from. So our role, I think, is to deal with the what-if issue and to know the law a little bit better than our clients do, even though they Google it and can read the statute. But the main thing I see is that I think the biggest mistake is people, the what-if people, look at the fraudulent transfer on too high a level, sort of a bird's eye view, and they focus on things like the badges of intent, badges of fraud, thinking that they have an answer or an explanation for why they did something. So the client will say, what if I create a trust for estate planning? Doesn't that mean I don't have the intent to defraud? Well, maybe, but that's not really the issue here, and that's just one of the issues. So what I try to do, and I learn more every time I do this, is actually read the statute. Every time I read the statute, I learn something. And possibly it's because every time I read it, I have had more experiences and more what-ifs, and I see something that years ago I might have said worked, and now I realize it would not have worked if it was challenged. So I'm not going to just sit here and read the statute with you, but I want to concentrate on some of the definitions in the statute, because if we read the statute and really understand the definitions, that's when you're going to get a real good sense for what does work and what doesn't work, and how to deal with the what-ifs that come into your office. So we'll go through some of the definitions and the important definitions and try to get a real understanding of how what this is. And one thing I often have to tell my clients is this, that I have these, you have a debtor, their backs are against the wall, or they think that they are. They see a problem down the road. They're scared, even though they may win the lawsuit. And I think that that often leads them to come up with some sort of crazy ideas about what they're going to do, and many people believe that they're smarter than the statute, that they can come up, and maybe attorneys too, that they could actually come up with something and an explanation that was going to work. So they'll be convinced, for example, that it's good estate planning and to put everything in tenants by entireties. Everybody does it. I've always done it. That has to be an explanation or excuse. Or I'm 60 years old. Everyone I know has an annuity. Why can't I buy an annuity? That's the end of the story. I mean, they just sort of think that they're going to be able to, by one explanation or one reason, justify what their what-if plans to do. And my standard response is this, and not to be demeaning to the clients, but these statutes were written by smart people. And the more I read it, I realize that the people who wrote these statutes and have maybe modified them over the years, I don't know, but they've been around for a while, these people collectively are smarter than almost all my clients, and they're smarter than most of us here, with maybe a few exceptions. These people are really smart who wrote the statute. And when you read it, you're going to find out that it really covers everything. I mean, it's really, I just cannot figure out how someone could take a plan that between the client and I know is designed to protect from creditors and try to find a hole in the statute that it takes it out of the fraudulent transfer statute. So the first thing is to be humble. Realize that the guys who wrote this are probably smarter than you. And if your client comes up with something they think is going to work, if you really read the statute, it probably is a fraudulent transfer. That doesn't mean you shouldn't do the transfer. That just means you're not smarter than the statute. So let me just start by making some examples of what I'm talking about in terms of reading the definitions. So the way I broke the statute down is I'm trying to make it, I try to explain things for people at the high school level if I can. So there's the statute on present creditors only, that's 106. I think my material says 105, that's wrong. And then there's the statute for present and future creditors. All right, so that's fine. And the first test, at least on the present creditors, I call the math test. It's just a numbers analysis. Because the statute makes it very simple. Nothing to do with intent, it's math. It says, if you're going to present creditors and someone makes a transfer, did the person receive reasonably equivalent value? Well, that's math. And was the debtor insolvent? Well, that's also going to be math. And if there's another section where it says payment to an insider, that's not just your friends or family, that could be a business partner. And it goes to whether the debtor is insolvent. Insolvency, by the way, there's a statute on insolvency, which I want to look at, it's 726-103. So this is just math. So let's look at the two mathematical analysis and make sure we understand. And we're going to concentrate mostly on insolvency because that's a tough one. Right? People ask me that all the time, and they misunderstand it. Reasonably equivalent value is not fair market value. And there's a case, but most people think it is, but it's not. And there are some cases, and one's in the materials called my Goldenberg case, but there are cases that say that reasonably equivalent value is, as I describe it, more ballpark. Are you in the ballpark of value so that you can transfer, you can give someone a good deal and still make a transfer for reasonably equivalent value? The case, I believe, I recall, says that a transfer value as low as 70% of fair market is still reasonably equivalent. I don't advise that you stretch it that far, but it's clear that if you do a transfer and sell something for real money, it doesn't have to be at the appraised value. It has to be in the ballpark. But the insolvency is the harder one, because the transfers that make the debtor insolvent, or transfers that while the debtor was insolvent or that leave him insolvent, are going to be fraudulent transfers. So there is a definition of insolvency, and it says, this is Statute 103. A debtor is again simple math. A debtor is insolvent if the sum of his assets are greater than his liabilities. All right. So the first question that comes up, the client response is, well, I'm just making this up. I transferred my real estate in my name, but of course I had $1 million in my IRA and $1 million homestead, and I could have got those. I could have, if I want to, take the money out of the homestead or the IRA and paid this guy off. So therefore, I'm solvent, right? I mean, I have the money. It just happens to be exempt. But the transfer of my non-exempt real estate or non-exempt cash was at a time when I was solvent, and it didn't leave me insolvent. Well, again, the drafters are smarter than that. So you have to get to the definition. Again, we're comparing assets and liabilities, and you have to get to the definition. And asset is defined as almost anything, but it excludes things that are exempt. So if you own something that's exempt under Florida law, that has two consequences. Number one, you could freely transfer that thing because it is not an asset subject to fraudulent transfer. That's good. But in terms of insolvency, you don't get credit for it. So that people who have, in my example, $1 million in their IRA, $1 million in their homestead, and have non-exempt assets that are limited to this hypothetical real estate, and that's all they have, and the transfer of the real estate is really, for insolvency purposes, a transfer of all their assets, because assets exclude exempt assets. And when you look at it that way, what will people try to transfer? Well, they're going to transfer things that are non-exempt. They're going to transfer everything that's non-exempt. So I find that if you look at the definition, almost all these transfers are transfers that either were made during insolvency or leave the debtor insolvent. Again, understand the definition. Now that's the asset side. So now the what if comes in and says, well, you're comparing my assets to my debt. I have lots of debts. I have a $1 million mortgage on my homestead. That's $1 million of debt, and the only thing I owe the bad guy is maybe 100, say 100, 250. It's going to be more than that, but say 250, 500,000. I owe the bad guy 500,000, but I owe Bank of America $1 million. So, I have all these other debts and we put that into the insolvency, but under the insolvency definition, again, it excludes, when you look at the amount of debt, it also excludes debts that are secured by exempt assets. It doesn't say mortgages when you're homestead, but that's really what it means. So when you're doing this math test, it's important to concentrate on the definition of assets and the definition of debts. And I think you're going to find that most of your clients who come in with their what-ifs are going to be making transfers that are either during insolvency or leading to insolvency. Now, in the future, the intent of fraudulent transfer and the badges of fraud are, of course, not involved in the math test as the present creditors. They only come in when you're looking at the other statute, which is, I think, .105, where it, I'm just going to get, I don't have my tables, not big enough. 105, 106. Yeah, so if you look at the broader statute, it says transfers as to present and future creditors. And it says A, with the actual intent to defraud, and then or without receiving reasonably equivalent value, and it goes into insolvency. But it's the intent to defraud is as under 105 is where you get into intent, and because intent is very hard to prove, that's when the statutes and the bankruptcy law lays out these well-known badges of fraud. And the mistake here, I think that I see, is that almost any transfer is probably going to violate one of the badges of fraud. And it's important that there are cases that say that just because you miss one of the badges of fraud, it does not make a transfer a fraudulent transfer. So when you get into court, the creditor's attorney is going to argue, well, see, he broke rule number 6, whatever that is, or rule number 5, and therefore he failed a badge of fraud, and it's a fraudulent transfer. But you have to understand there are several cases, and most of them are in bankruptcy, where it says that that you have to look at the whole picture as to what the intent was, and then get back to insolvency. But I'll say again, I think that on most transfers that smell like fraudulent transfers are going to fail under the statute, and they will be caught by the statute. But if you do have a bona fide transfer, even the good ones, where they're made to third parties, not insiders, made for reasonably equivalent value, they still may fail one of the badges. But don't be dissuaded by it. Just get the law that says that's okay, and fight it on other grounds. So the cases that we're talking about refer to what's called the totality of circumstances, and you need to know that law if you argue this in court. So again, the definition of asset is important. In terms, there's other couple of definitions I want to point out, and one is the definition of claim. There's a statute on definitions somewhere. The point is that a creditor is anyone who has a claim, but claim is very, very broadly defined. Okay, claim certainly doesn't mean a judgment. Claim doesn't mean the debtor is in default. Okay? The claim doesn't mean a cause of action accrued. The claim in the statute means there's a debt owed. So it's very broadly defined. So almost anybody could be come in as a claimant, or allege that a transfer was made when there was a claim pending, because the definition of claim is so broad, as is the definition of transfer. That means every mode of parting with an asset. That means cash. That means a security interest, granting a security interest. That means granting a right or an equitable interest in property. All of that may come under the definition of transfer. The other statute and definition I want to get into is a fraudulent loan. This is 726-201. I see this a lot, but it's the family loan. And so here's how it goes. I owe my father, brother, mother, whatever, money. They gave me money when I started the business. They gave me money when I went to school. I told them I would pay him back. In fact, I signed a note, and I haven't paid him back, so now that the bank is after me, I think I'm going to pay him back. Or that I just owe him money and I want to trade that loan for an interest in a property. I want to trade that debt for an interest in an LLC. The basic premise of the what if is the fact that there's a debt to an insider. But you have to read that definition, because it says that a loan where there is no payment or demand, I think it says for 2 years, is presumed to be a loan that is fraudulent under the fraudulent transfer statutes. And usually when I see these loans, there is not only, well, there may be a promissory note, but often there is not. But almost always there is not a payment history. And the client, our debtor, has not been paying the loan. There's nothing on the tax return to show a loan payment. There's been no demand or letters or lawsuits written for over 2 years. But as soon as our debtor gets in trouble with his lender, all of a sudden, parent, partner, or friend is all of a sudden going to make a demand for the loan. Well, it just doesn't smell right. And I think a creditor, I haven't seen too many attacks on these, frankly. Something I just come across. I haven't seen too many people figure it out, except certainly don't think the debtors understand that the liability, that this what if is not going to work, that if it doesn't really look like a real loan with payment and demand, the idea that the family creditor all of a sudden is going to demand and sue and get liens on property or is going to get paid off is going to be subject to attack under this statute. Another example of they thought of everything. But I think it's a common what if. I see that all the time, and it's just something that people seem to believe is going to work because they believe there's a debt. And there maybe is a debt, but if it hasn't acted like a debt, the courts may not treat it as a debt. The fraudulent conversion statutes, which are sort of in a separate section under the 222, are exemption statute. And again, it's important to understand the definitions here. It's any transfer of a non-exempt, again, the word asset, and of course, the only kind of asset is a non-exempt asset for these statutes. The transfer of a non-exempt asset to an exempt or immune asset. And in this statute, the future creditors and present are treated alike. And in this statute also, you have to show the intent to defraud, bringing in the badges of fraud. So those are the practical definitions I wanted to discuss, and because I think that every time you read these, you'll learn something. So, oops, all right, let's see where we are in time. Okay, so I'm going to sort of pick up the pace a little bit so we can get through this. The next topic I want to talk about is transferee liability. And what I tell clients in terms of this is the client comes in with these what-ifs that I'll give this to my partner, give this to my family member, and I say, do you really want to get your family members involved in your problems? And that's really the biggest thing with the transferee liability, even if it's a spouse, that although there's no liability to a transferee who has acquired something in good faith and paid reasonably equivalent value, the law says that if there is a fraudulent transfer, the creditor could sue or will sue, has to sue the transferee to recover. But moreover, if the transferee, this family member, has sold or spent the money, the creditor gets the judgment for money judgment against the transferee. So, example, well, I'm going to give all the money to my wife. Wife then spends the money or does something with it. The money's no longer there, so the creditor now has a cause of action for a judgment against the wife for the money, or because the transferee, I'm just using this example, it could be anybody, transferee has dissipated the property. You know at least that the recipient of the property is going to be a defendant in a lawsuit and is likely going to have another attorney, a separate attorney representing him. So even if we're not talking about money damages, by making a transfer to someone you like, well, they may not like the result. I mean, you're going to basically be dragging someone in to your problems, and it's not a nice thing to do, and it often doesn't turn out that well. So please, before you make, not saying to attorneys, but please, debtors, before you come up with some idea of who's going to get your property, consider the effect that's going to have on these people. Statute of limitations. And then we're going to talk about proceedings supplementary. Well, everybody knows that the statute of limitation on fraudulent transfers is 4 years, sort of. So the question comes is, when does the clock begin to run? And this is interesting, I think. Well, the clock obviously starts to run, under one view, is when the transfer is made. So if you made a transfer in '06 and we're now in 2013, the general rule is that you're beyond the statute of limitations, so let's start there. But there's another part to the statute that says it begins when the transfer was made or when it reasonably could have been discovered. I haven't figured this one out yet, maybe because I haven't been involved in a particular case that involved this particular issue. But I think that what that gets at is that if the debtor made an affirmative attempt to hide the transfer, as an example, I have seen a case where debtor does a deed to friend, but they don't record it. So they made a transfer effective between themselves, but affirmatively took steps to hide it from the public. Well, okay, the clock is not running at that point. But I don't think it means that the transfer could reasonably have been discovered when they take a debtor exam after the judgment, because it doesn't seem common sense that a creditor could argue that, well, I didn't know he made the transfer until I got a judgment and took his deposition, then I found out he made a transfer. Well, if that's when the clock runs, that no transfer would ever pass the 4-year statute, because the creditor won't know until he asks the questions. Probably, and if someone knows a case on this, let me know, because I just haven't had the experience with it. Probably the transfers that are made on the record, like a transfer of an account title on a stock account, or a transfer, a deposit of money into the bank, I think my impression would be that the intent is to start the clock when that transfer was made, because there's no attempt to hide it, and it could have been discovered if someone knew to ask. But it is the thing about the 4 years, that if it looks as if the debtor tried to hide the transfer or make it just between friends, so to speak, I don't think the clock's going to begin to run. The other thing I want to get into today is something I just sort of had experience with the first time within a year, and then again within the last week, actually, and there's a case that came down on this, but this is the statute of limitations under the Proceedings supplementary statute. So 5629, Proceedings supplementary. I think Mike Markham's going to talk this afternoon about the debtor collection tools that we should know about, so I'm not going to get into this deeply, but Proceedings supplementary I found to be a misunderstood and underutilized collection technique from the creditor side. And you all should read the statute. It's one page, it's very simple. And it's like, for example, it starts off with the right for the creditor to, when they start proceeding supplementary, require that the debtor appear before a magistrate and be questioned in court about the nature of his assets and transfers of assets. And to bring with him whatever materials are demanded, such as stock certificates from corporations, other documents, partnership agreements. And I found that from dealing with my debtors that this is a much more intimidating tool than just being asked to sit in a deposition at a court reporter's office. We've in one case many years ago where it basically led to collection of money. I mean, the judge said, look, either give this back or you're going to jail or you're under contempt, and which gets to the other part of this statute, which is that the remedies, if you read the statute, 562910, the remedies include enforcement by contempt for not for not paying a debt. We can't imprison people for not paying debts, but for failure to abide by the order of the court in a proceeding supplementary. You do have the additional remedy of contempt and also the assessment of attorney's fees against the debtor. Well, I guess that just means tacking on more money to the judgment possibly, but it does make it, it just does make it a bigger number to compromise. So I don't want to get into the details of it because I'm going to leave that possibly to Mr. Markham. I find from the asset protection side, I find it intimidating of the clients. And I think when these clients come in with the what-ifs and the fact that, well, we'll do the fraudulent, I'm going to do the fraudulent transfer and that'll really frustrate the creditor, and all these pie-in-the-sky kind of planning things, I think that I try to point out this Proceedings supplementary statute and just to sort of emphasize that these guys on the other side have some remedies that are going to help them. So just don't be surprised if this thing's implemented. Now, the good news from the debtor standpoint is that a lot of creditor attorneys either don't use it, don't understand it, or misuse it, most likely misuse it. And what I see in the practice is that Proceedings supplementary statutes are used, I mean, you can open it by motion, and the motion is going to be granted, and it's usually used as a predicate to opening up a fraudulent transfer action. And it can be, and that's part of it. But my point is, when you read it, you see that there's other remedies involved, other remedies in Proceedings supplementary, not just limited to opening up the form for fraudulent transfer. And I think that the clients need to be aware of it. And specifically, what I wanted to talk about here is getting back to the statute of limitations. There's something in the Proceedings supplementary that says that you can reverse a transfer to a relative or confidential party, insider, made within 1 year or after the service of process. Okay, so that is interesting. This is how it came up in one of my cases that I'm somewhat involved with. Lawsuit this is an old case, so a lawsuit I think was filed in 05 and 06, and within a year before that, or maybe even after, the debtor transferred some LLC interest to an insider, and the debtor was sitting back and smiling and say, clock's run, 4 years is over, right? It was 06, now we're in 13. I did the transfer 6-7 years ago. But the transfer is still within the statute under the Proceedings supplementary because it was done within 1 year of service of process. So the issue then was, well, how can we have two statutes of limitation running? I mean, is it the 4 year under the fraudulent transfer? Is it the 1 year under the Proceedings supplementary? It just doesn't seem right. It doesn't seem fair that we can go back beyond the 4 years. And there's some cases on this, and one of them, I believe, came out in our bankruptcy court up in the Middle District, and again, in a bankruptcy proceeding, and the ruling was that the statutes of limitation, the Proceedings supplementary statute is an independent. It runs on a separate separate train track. Okay, it goes its own way from the fraudulent transfer statutes, and therefore the statute of limitation under the Proceedings supplementary can be applied, and you can come back and go after an asset that was transferred within 1 year of the service of process, even though it's 4 years or more behind us. But the court pointed out that this only applies to personal property. It doesn't apply to real estate. And again, on the face of the statute, it says transfers to a relative, or I don't have, my statutes fell on the floor. I can't even read them, but because I don't have enough table space. But you read it yourself. It's 5629. Was that 10? I think. It's only to certain people, but again, personal property. We're not just talking about jewelry. We're talking about partnership interest, LLC interests, and a lot of these debtors have already put all their real estate inside LLCs. So watch out for it. Make sure you tell your clients about the Proceedings supplementary statute, and hopefully your creditor attorney is not experienced enough to use it. However, I just, again, you'll find that the bigger law firms and the more sophisticated discovery creditor people are very familiar with it. As an aside, now you got me on another topic. Just as an overview, I was thinking about this in the last few days. I'll get back to this later. I want to talk about the practicality of who actually pursues these fraudulent transfer cases, but I'll get back to it later. So the next thing I want to talk about is getting back to what Dennis talked about, the initial, in the introduction, was the liability of third parties to fraudulent transfers for planning or being involved in the transfers. what the higher courts in Florida, the appellate court and the Supreme Court, finally understood, something that Dennis has been preaching for over a decade, is that fraudulent transfers are not common law fraud. The common law fraud involves lying, cheating, stealing, taking money from old ladies with the intent to lie, cheat, and steal, incurring damages. All right, it's doing bad stuff to good people, and you make money doing it. That's common law fraud. But fraudulent transfers, the term involves a collection remedy. It's a collection tool to undo planning that was designed to protect assets from judgment creditors. There's not the lying, cheating, stealing, intent to harm, and there's no incremental damages involved in fraudulent transfer planning. So that's in again, the high school level, explanation. But the courts finally got it. Most of the courts finally got it, which led to cases in Florida that have realized that because of this distinction, that it led to the more sophisticated distinction, which is that fraud, the old, Madoff fraud, that's a tort. It is just a tort. It's not. There are contracts and torts. This is a tort. It's a wrong that is a tort. And whereas the collection remedy, fraudulent transfer, is not a tort, because for various reasons it doesn't incur damages, and it's not one of our torts. So that's step one. And the next step in the analysis is that the remedies of conspiracy and aiding and abetting are available for torts. All right? So you can have conspiracy to commit a tort, aiding and abetting commit a tort, and also torts have other consequences. One of the cases in the materials talked about personal jurisdiction. You have personal jurisdiction over a party if they commit a tort in Florida. So there's various consequences of being called a tort. Aiding and abetting is one. But if you're a non-tort, then the aiding and abetting, conspiracy, and other kinds of theories don't apply. And that is, I think, the sort of intellectual reason why once you show that this is not fraud, not a tort, then all the theories of third-party liability will not apply, and that is the law in Florida, that there's no remedies, not just attorneys, because the main cases involved, the one case I was involved with involved a brokerage company, a financial firm, and then the Freeman case involved a bank. So it's not just the causes of action against attorneys, but the financial firms who handle the money. So in Florida, we have the case law that says that sort of shields the people from the conspiracy and other theories based on tort. But that's really not the practical end of this. So let me explain that the judges at the high levels get it, but the judges that you'll come in front of on a day-to-day basis, they don't get it yet. All right? I mean, some of them do, but a lot of them don't. And one of my clients was in a court, and this is not a war story, it's just an example that I don't litigate my own clients. I don't do any litigation, but the litigating attorney told me last week that he was in front of a judge, and the creditor was trying to get damages, I believe, against a third party involved in a fraudulent transfer, and the judge made some comment of, oh, he helped this debtor commit a fraud. That's horrible. There has to be a remedy. And the attorney successfully came in well prepared with these cases I just alluded to, and was able to turn the judge around, and basically by putting a Supreme Court case in front of the judge, change the judge's mind. But what's instructive is that you will often, in the real world, go before judges at the county and circuit court level who haven't heard about these cases because they don't deal with them every day, and who have the same mindset or prejudice that people had, that everyone had years ago, that a fraudulent transfer is a fraud and a wrong, and it has to be remedied, and anyone who touches it should be held liable. So be prepared. Don't assume that The guys in county court who are dealing with foreclosures and domestic matters are really deal with this every day. They don't, and don't assume that they're not that they're not smart. They're smart. It's just that they have other things on their plate besides asset protection planning. So, that's the reality is that you still have to fight the fight and be prepared and make sure you have the cases with you. So some of these cases in the materials, there's the USIM case was the case that said that for the earlier case, it said that fraudulent transfers are a collection tool only. There was the Danzas Taiwan case, I believe, said that because it's not a tort, you can't get jurisdiction. And there are many, many cases that agree with the absence of third-party liability that are much earlier that came out of the bankruptcy arena. And I cited a couple in the materials, the Mack case and Elliott case. So the bankruptcy courts in other jurisdictions got this distinction much earlier. And again, on the practical side, I find that the bankruptcy judges are more hip to this distinction, and they get it. Most of them get it, because these judges deal with these issues day in and day out. Most of the law on fraudulent transfer you'll find is made in the bankruptcy court, and for various practical reasons. Because, well, I mean, they deal with it, over and over. They don't deal with divorces and mortgage foreclosures. They deal with this kind of stuff every day. So most of the law is made in the bankruptcy court, and the law absolving people from assisting and aiding and abetting fraudulent transfers had been the law in other bankruptcy districts for some time. So just an observation. Okay, next, and I want to hit on or discuss the fact that what I just said about the law on third-party liability, don't interpret that as a willy-nilly to do whatever the heck you want to do. I mean, use some common sense. So my own guidelines are that, first of all, I don't take control of the assets. I don't want the money in my trust account. I'm just here to discuss the law. I don't become a player in your client's game. People want to help the clients. They want to assist them for what the attorney believes is planning for a proper purpose. They want to help the client preserve their money against the judgment creditor. It's all well-meaning, and you don't believe that just because there's some Florida Supreme Court cases that you're going to just be able to do anything. Use common sense. My common sense is that I don't really, I discuss the law. I don't draft documents. I don't draft deeds to transfer property. Maybe, I'll do an estate planning document, but it really has to be pretty clean. I don't want to start doing trust when there's a judgment on the horizon. You don't send them to an estate planning attorney. Right? Don't try to do it all. Just use very, very common sense. You don't want to become a witness in your client's case. So even though there's law there, you don't want to have to go through what I had to go through, basically, which wasn't that bad, but you just don't want to have to, you don't need to do it. Don't try to do everything. Draw the line where you're helping clients. I think your role as an asset protection planner should be educate the clients on the law, but don't join the game, all right? Don't touch the money. Don't draft the documents. Don't backdate documents. Just don't do it. If they need to transfer real estate, let them go to a real estate attorney. And most important, don't litigate your own cases. If you have a client who, even before they came to you, made some kind of questionable transfer, you don't have to be the one in court defending it. Because by giving the advice and consulting, I think your hands are still going to be on the transfer, or you reviewed the transfer, or the client will make a transfer after speaking with you, and you don't need to be the one in court before the judge for the other attorney to turn around and point at this guy who assisted these transfers. It's not necessary. So I think most of the I know Alan and Dennis, I know most of the people I know who advise on asset protection are not litigators and they don't litigate their own cases. Okay, checking time. So I'm going to skip over a section. And what I want to get to is discuss some of the what-ifs that I have seen from time to time. And I guess you have your own what-ifs, but some of these I talked to, and the most popular, of course, is transferring things to a spouse, transferring assets to a spouse, making, what if I create a trust for my children? If a debtor has joint accounts with a spouse, and if the debtor has no individual accounts, and if the debtor has non-exempt money coming in from a business, I think there is a defense that, and it's been recognized in cases, that if the debtor is doing what the debtor has always done, in other words, if the husband and wife have a long-standing practice of owning their assets jointly, the debtor does not have to set up special accounts in his own name because there's a potential lawsuit, so that he can preserve the money sort of on the table to make sure it's easy for the creditor to get the money. I mean, he doesn't have to change his practice to make it easier for the creditor. That's different than changing his practice to make it harder. But if his practice has been that all money is in joint accounts or all assets are owned jointly, and he's continuing present practice, I've seen that as a reasonable defense against the transfer cases. Again, if he changes his practice the other way, it could be a problem. The gifts to what if I give everything to a trust for my children? Well, there the client doesn't understand that once he does that, he can't get the money, and they really don't like that. When they find out that if they give things to the children, they have they're not supposed to take the money back. And of course, it's a gift, and if it's to an insider and go through all the definitions, it usually doesn't work if there's a potential threat on the horizon. Another what if, again, is paying these undocumented family loans. We talked about that before. Let's say paying a valid debt, not the fraudulent loan, but paying a valid debt. Now in bankruptcy, there's a preference concept in bankruptcy that deals with paying unsecured debts. And the idea there is that we want to treat all the unsecured debts equally. So if you make a payment to an unsecured creditor within 90 days, that's a preference. The trustee can get it back. But there's the other statute under it, which we talked about, 726, paying an antecedent loan to an insider. If you pay off even a valid loan, and there's a valid loan to an insider, by the paying it off, it may not even come under or may or may not come under the bankruptcy preference, but it can still be a preference. It was done within a year, I believe, to an insider. So just because you can pass the bankruptcy preference doesn't mean you can pass the preferring a insider is still considered a fraudulent transfer under the fraudulent transfer. So there's two different preference concepts. Okay, let me skip down a little bit. Another idea, another what if is this. I'm going to make up a hypothetical. What's up here? I have I am talking about the debtor speaking. I own a piece of real estate with a partner, a parent, brother, or I owe them a loan. So what if the partner, the non-debtor partner friend, makes a demand upon me that they demand that I transfer the property to an LLC or partnership. They demand that I pay off the loan. So, see, Your Honor, it wasn't my idea, it was his idea. They're the ones who, wrote me letters and demanded I make the transfer. Okay, well, the problem with that, in fact, years ago I believed that, but I don't believe it anymore. But the problem with that is that if you look at the statutes, that if you make a transfer to an insider when you're insolvent, and then there's an and that the transferee knew or had reason to know you are insolvent, it could be set aside. So this creative idea of creating this demand or note to show the creditor or court that it wasn't my intent, it wasn't my idea, it was his idea, what you've also done is established possibly that this third party knew you were insolvent. So you sort of hang yourself. So the creditor can come in and say, look, this partner knew he was insolvent, he knew he was in trouble, that's why he made the demand, and the fact that he made the demand of the transfer shows that he was part of it, he knew about it. So trying to initiate a transfer to an insider by a demand from the partner or insider, it solves one problem but creates another. It creates the problem that the partner, insider, potential transferee knew of the insolvency or had reason to know of the insolvency, and it's going to hang the debtor up on that statute. What if I take the real estate and put it into a partnership? Don't I therefore get reasonably equivalent value because I've obtained an interest in the partnership? Yes, but reasonably equivalent value is just one of the tests. And there are cases out there, and I'm not citing cases, I'm just telling you what it is. There are cases out there where that's been raised and the debtor is usually lost. It's been still considered a fraudulent conversion or to hinder, delay creditors. You see, because the fact that they got reasonably equivalent value, maybe even if that's true, it's still one of just one of the tests of intent. And if you argue, if the cases find that you have to look at the totality of the circumstances, the courts will look at the totality of the circumstances. And if it looks as if there was no other reason, or if there was not a good reason for creating or moving things to a partnership, or if the transfer was done when a problem was on the horizon, I don't think receiving an interest for the transfer is going to solve the fraudulent conversion problem. I mean, you can argue it. You can't sleep well at night. I mean, don't bet the farm on that argument. Okay. I mean, here's a what if that actually, may delay, I guess, a creditor. There's what if I close my bank account and then move my bank account to another state, or change banks, so that I'm basically, with like a shell game, keep moving the money ahead of the creditor. I mean, that's sort of interesting, because I think that if someone debtor has a bank account in their own name, and they go from Bank of America to Wells Fargo, or if they go from Bank of America to E-Trade or some other internet bank or somewhere out of Florida, I think technically that's not a transfer, because they haven't transferred title, and technically it's not a conversion because they've not converted the money into an exempt asset. And I don't think it's a permanent solution, because at some point I believe that under the equitable remedies available under the fraudulent transfer statutes, the creditor can get an injunction possibly to stop the shell game. But it's certainly better than just leaving the money on the table. And under that what if, if the client asked me that, I would say, okay, but you don't want to lie, so make sure that when you either testify at a deposition, or if you're filling out a fact information sheet, make sure that at the time you testify that the money is where you say it is at the time of the testimony. And I guess that's the point. Now, if you testify that it's a Bank of America, it doesn't have to be a Bank of America tomorrow. Just make sure it was a Bank of America when you testify. So it's a sort of a shell game with money. It maybe probably not a permanent solution, and there are remedies to stop it, but I've seen people do it. And so far, I haven't seen it argued that it's any kind of fraudulent transfer, because I don't see it's a transfer of title. So anything you do where you actually don't transfer ownership would not come under the statute, or anything where you take move money to a point where it's still non-exempt, then you haven't done a fraudulent conversion. Well, what if I do something for estate planning? I'll put it into a estate planning trust, I'll put it into a GRAT or CRT or something or whatever. The question I ask is why? In other words, do you have estate tax liability? If you're going to say you did something for estate tax planning, do you have an estate tax issue? You don't have to have $10 million, maybe it's less, but do you reasonably have an estate tax issue? If you have $1 million or $2 million of assets and you're married and you say you did something for estate tax planning, I don't get it. I mean, if someone's going to come with a what if, tell me how it really works and why this actually helped you with an estate tax. Same thing, what if I just take the money and I'll buy an annuity? All right, well, how old are you? I mean, I think that's a reasonable plan for someone 60, 70 years old, and I think it's very well defensible. You don't have to stop your retirement planning just because someone's suing you. You don't have to stop contributing your normal amount to your IRA. You don't have to stop contributing what you have been contributing year after year after year into a retirement plan. And you don't have to leave, again, the money on the table to put your retirement at risk. So it helps if you have a financial plan that's suggested, and it really helps if you have you just can't say estate planning, retirement planning. And the courts in the bankruptcy cases will often look to the age of the debtor and the other income of the debtor, and is he working, is he disabled? So these other factors will be applied reasonably to come up with a reasonable analysis of whether buying the annuity or the life insurance product or the estate planning trust, whether it was valid or whether it was just another scheme to protect the money. See if I have any more time. I don't. Okay, so we're about the end. See if I have anything, and I'll do anything in 1 minute. Okay, well then I'll just sum up. I mean, I didn't cover everything, but it just have to be practical about this stuff. Don't be naive. Don't believe your own plan. Understand that the statutes are good. It's very, very difficult to beat the statutes, and it's also pretty difficult to beat, a well-funded and knowledgeable creditor. In closing, the ultimate question is, does the client do one of his what-ifs? And that's sort of the interesting question, because what you'll find is that, to use the analogy I use, there are cures and treatments in asset protection planning. Buying a homestead's a cure. Everything else is a treatment. Okay, you'll live longer. You'll have your money longer. You can negotiate better. You put yourself in a better negotiating position. But understand, client, these are only treatments. Some work, some don't. But don't believe that this what if that you come up is some kind of permanent cure to your situation. It's not. Just take it for what it is and then make a business decision. Thanks.